Morning.
Oh, this is the. Uh-oh. Got your haircut, Steve?
Yes. Oh.
This is the biggest agenda ever. Oh, excuse me.
Okay, you're
I'm
fine.
sorry.
You're fine.
Good morning, everybody. Let's rise for the Pledge of Allegiance. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good morning. Happy Monday. Happy Valentine's Day. And I will note all members of President except Mr. Wanilowski, who told us treats we had a count. I will move to excuse his absence. If there's a second.
Second.
Thank you. All in favor?
Aye.
All right, I will move to approve the minutes from the January 11th, 2022 and January 25th, 2022 board meeting. If there's a second.
Second.
Thank you. Any question or comment about those minutes? Okay, hearing none, all those in favor signify by saying aye.
Aye.
And I will move, it's going to take a minute here, to acknowledge the Secretary of State directives. These are directives 2022-02, instructions regarding the review, examination, and verification of supplemental part petitions proposing an initiated statute. Directive 2022-03, House Bill 93. Directive 2022-04, updated election official manual. And then 2022-05, Chapter 1, introduction. 2022-06, Chapter 2, Board of Elections, Organizations, and Operations. 2022-07, Chapter 3, Security. 2022-08, Chapter 4, Voter Registration. 2022-09, Chapter 5, Ballots. 2022-10, Chapter 6, Precincts, Polling Location, and Precinct Election Officials. 2022-11, Chapter 7, Absentee Voting. 2022-12, Chapter 8, Provisional Voting. 2022-13, Chapter Election Day Voting. 2022-14, Chapter 10, Canvassing the Vote. 2022-15, Chapter 11, Post-Election Activities. 2022-16, Chapter 12, Voting Systems. 2022-17, Chapter 13, Petitions. 2022-18, Chapter 14, Candidates. 2022-19, Chapter 15, Political Parties. 2022-20, Chapter 16, Statewide Initiatives and Referendum. 2022-21, Chapter 17, Miscellaneous Duties. And 2022-22, Examination and Verification of Candidate Petitions filed in Secretary of State's office. And if there's a second.
Second.
That is, these are all a result of the new Ohio elections manual that was issued. And we're acknowledging receipt of those. And I guess I have a question. We've been through it. Staff has reviewed it or in the process of doing that?
Staff are in the process of doing that now. What will probably happen at our next meeting, the March meeting, is already in our initial review. It looks like there will be a few new policies that we'll have to create here at the board as a result of these updates, as well as update some of our current policies to meet the criteria that's set forth in there. Peter James is the individual who is leading up that process.
Okay, terrific. And you'll keep us posted if there's any significant changes that are set forth. I'm not aware of anything.
Yeah, I think the most significant ones are probably the ones that cause us to create a policy, such as now we have to come up with board members and director, deputy director, a signature stamp policy when it's allowed and not allowed, or online publications, we have to have a policy on that. So that, but as far as the structuring, nothing, I don't think too critical. Again, Peter will have a summary for us, highlighting some of those things.
Any other questions or comments? Well, hearing none, we have a second. All those in favor signify by saying aye.
Aye.
Motion passes unanimously. And I'll move to approve to outsource the printing and mailing of vote by mail ballots for the May 3rd, 2022 primary election. Hopefully that'll happen. All right. Second. And this is required now, right, Mr. Blatty? The board has to approve it, and then you have to go to the Secretary of State's office.
Right. So if any board wishes to use a third-party vendor to send out their vote by mail ballots, which because of our size we do, I believe it's 70 days or more before an election, this board needs to go ahead and take this action. And once this action is done, then we have up until 60 days to provide an application request to the Secretary of State's office that would include a copy of our contract, as well as they have a questionnaire that we have to provide those answers to. And then the Secretary of State's office, upon review of that, will issue us an email, hopefully saying that we're good to go in outsourcing this functionality.
Any other questions or comments? Hearing none, all those in favor signify by saying aye.
Aye.
Motion passes unanimously. And we're on now to a hearing on the petitions received on February 1st, 2022, for the recall of the mayor of Newburgh Heights. Very good. We're going to be, what I'm going to do is kind of tee this up. What has happened is petitioners have filed a recall petition for the mayor of Newburgh Heights. And our staff has received those petitions. However, as we typically do, our staff, then Mr. Lawler, who heads up that department, reached out, and I know our deputy and director reached out to the law director of Newburgh Heights and said, can these be accepted? Can we place them on the ballot? And we got an opinion from him that said, no, they shouldn't be. And then the petitioners hired an attorney, Mr. Bray, who has since written to our attorney here, Mr. Musson, and the board saying, no, we think it should be on the ballot. So I'm with my two colleagues here, both attorneys. This is what we call kind of a summary judgment issue. There are no facts in dispute here. Petitions have been filed, the law has been written, and two attorneys are interpreting it a little differently. We've also asked our attorney to weigh in on this matter too. So having said that, I know Mr. Bray, are you here, sir?
Yes, sir.
Okay, Mr. Bray, you can approach if you'd like. We have Mr. McMahon, the law director for Newburgh Heights here, who has also issued his opinion to us. Trying to look for that. Yes, McConville, thank you. Luke McConville, who's issued opinion. I know Mayor Elkins is also in attendance here today, and I imagine the petitioners. Having said that, and Mr. Bray, thank you for coming up from Columbus. Okay.
Glad to do it. Actually, enjoy.
So what we're going to do is I'm going to start with Mr. McConville, because he is the one that first said, you know, Board of Elections, I don't believe our charter permits us to do this. So we're going to hear from him. Like I said, we have read all the opinions. You can stay up here, Mr. Bray, if you like. We've read your opinions and read the law on this, but we'll give you, if you want to give us 5 minutes of summary, we may interrupt you, an argument. But why don't you go first, Mr. McConville, and then we'll hear from Mr. Bray and then our attorney. Go ahead.
Thank you, members of the board. My name is Luke McConville. I'm the law director for the Village of Newburgh Heights. The Village of Newburgh Heights is a general plan statutory village organized under chapters 731 and 733 of the Ohio Revised Code. It's important to note that the statutory framework in Ohio sets forth a menu of options for statutory municipalities, and that menu includes the general statutory plan that the village is organized under, along with optional plans of government set forth in Chapter 705. The 705-92 provisions that relate to recall apply only to those optional plans of government. They do not apply to the general statutory plans. It's also the case in Ohio that our Constitution allows home rule authorities and the ability for local governments to adopt their own charters. I want to refer particularly to Ohio Constitution Article 18, Section 2. That section states that general laws shall be passed to provide for the incorporation and government of cities and villages, and additional laws may also be passed for the government of municipalities adopting the same. But no such additional law shall become operative in any municipality until it shall have been submitted to the electors thereof and affirmed by a majority of those voting thereon under regulations to be established by law. The issue here is that the Chapter 705 and 705-92 that's at issue are part of additional laws. That can be seen from the legislative history, as well as from an Attorney General opinion, 1989 AG opinion 2-212. If you think about Mr. Bry's argument related to statutory construction, the statutory construction must also include the other statutes within 705. And I refer particularly to 70504, which makes it clear that the provisions of Chapter 705, including 70592, which is referenced specifically in 70504, are not operative until a municipality has made an election to adopt one of those particular plans. And in this case, of course, the Village of Newburgh Heights has not made that adoption. I pointed out in my correspondence to you that commentaries under 70504 have interpreted it this way. And in particular, I refer to the Gotherman and Babbitt treatise, Baldwin's Ohio Practice, Local Government Law, Ohio Municipal Law, Section 3.3, which states that the manner of the exercise of municipal powers is fixed pursuant to Sections 2 and 7, Article 18 of the Ohio Constitution. The determination of the manner of exercise of municipal power is vested in the electors of municipal corporations by the adoption of a charter under Section 7, by the adoption of an optional form of government under Section 2, or by failure to act, thus requiring operation under the general statutory form. They alone determine the form of organization of their municipal government. And that language is very critical to note. The electors of the Village of Newburgh Heights have not adopted a plan of government under 705. In essence, by failing to do so, they've chosen not to be governed by those provisions. Certification of the petition at issue would unlawfully disturb that choice. I think, again, referring back to the language in Article 18 of the Constitution, which indicates that additional laws only become operative when they're submitted to the electors. The problem with Mr. Bry's argument is that if his interpretation is accepted, then the statute, which is an additional law placed in 70592, would violate Article 18, Section 2 of the Constitution and thereby be unconstitutional. So that's a summary of our argument. I'd be happy to answer any questions, and I'd also, I hope to be afforded the opportunity perhaps to rebut any argument presented by Mr. Bry.
Okay, thank you, Mr. McConville. And Mr. Bry, you're to be heard, sir.
Thank you, Mr. Chairman, members of the Board of Elections, opposing councilman. I have great respect for Mr. McConville, although we disagree on this issue. I think since Mr. McConville talked about Article 18, Section 2, it's helpful to remind ourselves what Article 18, Section 2 actually says. It says, first of all, that general laws shall be passed to provide for the incorporation and government of cities. And secondly, and additional laws, cities and villages, and additional laws may be passed pursuant to a charter adoption. When they talk about additional laws, they're talking about something in addition to the general laws that generally apply to cities and villages, to municipalities. The dispute we have is whether or not the amendment in 2017 to revised code 705.92 made what was formerly an additional law that only applied to cities and villages that chose to incorporate a recall provision in their charters and made it into a general law that they have authority, the General Assembly has authority to pass that generally applies to all cities where they have a charter, not unless, of course, by virtue of the charter, they opt out of the general provision. Our position is that's exactly what happened when the General Assembly added the language. Mr. McConnell, for example, said statutory construction must include the other provisions of 705.03, 705. Presumably 9.1, although he didn't mention it. Well, no, that's not actually true. It's a general rule that we use Latin because words like use equal material. which is to say, in general, a rule of interpretation is you look at the other statutes around where you are. And that's what the Ohio Supreme Court did in 1976 when it was looking at 35-1791 and said, well, if you interpret, 705.9, if you interpret 705.92, the provision that deals with recalls, in light of 705.91, then you would limit it to charters that choose to adopt this provision in their charter. All right, so that's the general rule, but that's a rule of trying to understand what the General Assembly had in mind, what they intended. And the best way to determine what the General Assembly intended is by reading what they wrote. And they changed the law, and they changed, and yes, if the 1989 Ohio Attorney General's opinion was also some years before the 2017 change of the law. Both those cases were correct interpretations of the law as it existed at that time, because there was nothing in Revised Code 705.92 that prohibited that statute from being interpreted in light of other statutes until the General Assembly acted. And when they acted, they added the words that make it clear that that provision that says a municipality can have recall according to those provisions applies, I don't want to misquote it, notwithstanding Section 38, Article 2 Ohio Constitution, or any other provisions in the revised code to the contrary. That means you can't look at the other statutes and say, well, we're going to interpret this statute in light of another statute that might limit it.
Mr. Bray, let me interrupt. So you've looked at the Ohio Legislative Commission interpretation of this statute, correct?
I understand that Ohio Legislative Commission generally has an interpretation. I don't really rely upon that.
But have you read their interpretation of this section?
I don't have that. No.
Okay. And I'll provide it to you. I mean, it's just, it talks about the recall of municipal officials, which is the subject at hand. It says the act makes two changes to the statutory procedure for the recall of an elected official. First, it specifies that a recall petition is not valid after 90 days from the date of the first signature. Under prior law, no time limit applied to the collection of signatures on a recall petition, although the signer of an election petition still had to be registered to vote at the address indicated on the petition at the time the petition was filed. Second, under the act, the recall must be held at the next primary or general election occurring more than 90 days from the date the petition is certified as sufficient. Former law required the recall election to be held between 30 and 40 days. While continuing law might appear to authorize and prescribe procedures for the recall of officers in any municipality, in reality, the statute applies only to the municipality whose charter specifies the recall elections must be conducted in accordance with the Ohio Revised Constitution. The Ohio Constitution does not permit the recall of officers. As a result, the Ohio Supreme Court has ruled that statutes providing for recall are unenforceable. However, the court has held that a municipality may adopt a charter that provides for recall elections, and the charter may require those elections to be conducted according to revised code procedures. As a result, the act changes the recall procedure only in a municipality whose charter specifies that recall elections must be held according to state law. Now, while this isn't binding on this body or even a court, would you agree it's persuasive?
No, I would not. In fact, I have a quote Felix Frankfurt, who on some reflections of reading statutes 75 years ago said Spur's use of legislative history must not swallow the legislature so as to point to the clip that only when legislative history is doubtful we build the statute. Well, courts are no longer confined to the language we are itself confined by it, and violence must not be done to the words chosen by the legislature. Ohio traditionally doesn't have legislative history per se. We do have the LC reports. But having said that, if you look at the history of how this statute was passed, it was not in the House version. It was thrown into the Senate version when it went into committee. And so the LSC did not have a lot of time to put through this. And frankly, I don't think they accurately understand the history of the cases dealing with this or with the Article 2, Section 38 that they were dealing with. There was a 1922 case, Ohio Supreme Court case, that dealt with a situation where, pursuant to some sort of statute, a treasurer who had allegedly embezzled money was removed by the Board of County Commissioners without notice, without a complaint, without a hearing. And Article 2, Section 38, if memory serves, said that you can't do it. You have to remove somebody only by notice of complaint and a hearing. And therefore, that statute was unconstitutionally struck down. Now, the question then became later on in the case that was dealt with by 1948, the Hickley versus Edmonds case, which is the case that is a the Walker case. That's a 1948 case where somebody said you can't have a recall election because you have this 1922 case saying you have to have a complaint and notice in order to remove somebody for cause. And the U.S. or the Ohio Supreme Court in that 1948 Hickley v. Edmonds case said, well, that's not true. Recall is a totally different animal. Recall has nothing to do with Article 2, Section 38. You can recall something. And then you come to the state, the case, State Extra Lockhart versus Hauer, the 1976 case, where again, somebody is saying you can't have a recall election because of Article 2, Section 38. The Ohio Supreme Court in its first paragraph says, on the face of it, it looks like the Hickley case that said a recall is a different animal applies. But as we, in 1976, interpret the statute of 705.92 is interpreted in light of 1705.91 only to apply to charter provisions. So to the extent that the LSC report is inconsistent with the statutory history, and to the extent that it would seem to limit the first sentence of Article 8, Section 2, or Article 18, I can't remember what article it is, of the Constitution that says the General Assembly can provide for general laws, but the General Assembly can provide for general laws. It certainly would be constitutional for the General Assembly to pass a statute or to amend a statute saying that as part of the general provisions of the revised code applying to municipalities, they can recall unless they opt out. Because 705.91 still requires a separate vote on whether or not to have a recall as part of their charter. And what that now means is that if you vote no, you've opted out of having a recall provision. And if you vote yes, you retain what otherwise is in the case. It's just the opposite of the way they did it before 2017. So to answer your question directly, I don't find the LSC commentary either particularly clear or particularly persuasive. And I would rely upon the words of the statute of the Ohio Supreme Court if I wanted to understand it.
Sure. Ms. Sticken, did you have a question?
Well, I guess to your point too, it seems when I was reading your memo, you're relying on sort of an interpretation of the language of the amendment as we've been discussing. But that kind of along the lines of Chairman Hastings' question was, just it doesn't seem like to be much authority other than what you're saying, piecing together past precedent and even your interpretation of the language. I was going to ask, similarly to his interpretation, then he asked you about, are there any footnotes in the amendments, anything else you could provide?
Well, I have provided the rules of statutory interpretation. One, I think that the language itself is clear, and not just my interpretation. Secondly, there's a big rule that you shouldn't interpret legislative words as if they don't mean anything. And that seems to me the alternative. Either they meant something when they put these words into the statute, which is what the rules of statutory interpretation by the Ohio Supreme Court require, or we treat them as if they're meaningless verbiage. And we're not allowed to treat them as meaningless verbiage.
I guess I don't interpret it the same way based on plain language, given the other sections. So I guess that's where that's what I'm struggling to understand. Did you?
Yeah, I was actually, Chairman asked the question. I was going to ask you about the Legislative Commission language. But is there any way, given your position, that you see that the two statutes can be harmonized or reconciled in any way? Or you have the opinion that they are absolutely contrary and that the amendment somehow is incapable, the amendment language is incapable of being reconciled with the other section?
I think they're capable of being reconciled. And the way I would suggest that they're reconciled is that the statute saying that this is only part of the plan if it's adopted is still true. It's only part of the plan if it's adopted. But in other words, if it's not adopted, the recall provision is not part of the charter plan. That's still something that gives effect. It's a different understanding than the understanding that said that the 705.91 says that 705.92 only applies to charter, which, by the way, is an interpretation, not a direct language of 705.91. If they were inconsistent, if there were no way to reconcile the two, as I believe there is, then the most recent amendment, which would be the amendment of the new language, 705.92, would be the one that is required to be given effect. But at the same time, we are required to interpret them as reconcilable to the extent that there is an ability to do that. You can't, however, reconcile them by treating the new language at the beginning of 705.92 as if it didn't exist. And I'm not sure if there's a way to interpret that language other than by pretending it's not there that would give effect to the position that opposing counsel is asking the board to adopt.
Mr. Bray, is this a question of first impression? I mean, is there any case law in support of your position that's been litigated before?
I don't think it's been litigated either way, or at least if it has, I haven't found it. It's not evidently. I'm not saying that there may be something out there that I haven't found, but I did try to find something. I think this is the first time this issue has been addressed.
I would agree with you. I'm sure Mr. Musson, Mr. McConville, and yourself have all looked to see if there's some law that you can point to in support of your positions.
Well, you're a lot smarter than I am, so I see what you have time to do this.
Understood.
Just one other question, and I would ask the same question of the law director in terms of whether there's any way to harmonize the two provisions. But just moving one step away from the statutory issues, from the constitutional question seems to me to be important as well, because wouldn't you expect the village or the municipality to take into consideration they need to adopt a formal process, otherwise there's a potential denial of due process under the Constitution for somebody. You can just recall somebody under your argument, because based on the new language, how does the constitutional concern around due process play in to your argument?
Well, it sort of reminds one of the quote from some court in New York that no man's life or property or safety is general assembly's concession.
I'm sorry?
There's a quip that no man's life or property are secure while the General Assembly's in session. The reality is the General Assembly can change the law, can change general statutory law, and it does that all the time. And it does it in ways that affect municipalities fairly directly. I mean, it tried to change, for example, Newburgh Heights, I think there's a traffic jam. And originally they tried to change that, and that apparently was something that was problematic. So basically they're saying, fine, get a traffic jam, we're going to reduce the amount you get in local government funds. I mean, there are all sorts of things the General Assembly does, whether we approve or disapprove of them, that have a direct and significant impact on how you operate. The Ethics Commission, for example, did exist some years ago. They added that created duties of every public official in every municipality that weren't there before, even if they previously had charters. You know, the regulation on how much you have to report and how you report. There are limitations and changes on how you interpret the voting rights, that changed over time. When we passed the Constitutional Amendment in the late 1960s, giving the vote to 18-year-olds, for example, that changed the voting franchise of every municipality, even the charter ones in the state. So you can have general law, and you can argue about, this isn't fair in some sense. But in another sense, you can, if you don't want it there, have an amendment to the charter that takes it up.
My question is a little bit different than whether it's fair. My question is whether or not your position ultimately will result in some constitutional violation of due process right for that's my question. Not whether it's fair, not whether the General Assembly could change it, but whether or not the constitutional implication is one that would result in a violation. This is all first impression, I agree. I mean, but I do think, that there is a constitutional question, and your position directly implicates that potential, raises an issue around violation of the Constitution. So that's what I'm looking for, your sense about whether it's a violation, not whether it's fair.
Can I address that as well?
Yeah.
To respond to your question, Article 18, Section 2 permits the General Assembly to pass laws, general laws, to provide for the incorporation and government of cities and villages. There's nothing in Article 18, Section 2, or in any court case, that says the General Assembly can't change those laws, or that it would be a due process violation for it to do so.
Thank you. Mr. McConville, you had something to add?
Yeah, and I agree that there's nothing that prevents the legislature from changing laws, but in this case, the particular law that they changed is of importance because of its placement in the Ohio Revised Code. It's located in Chapter 705, which is a chapter that's titled Optional Forms of Government. 70504 and Chapter 705 generally are only applicable if the electorate chooses for them to be applicable. 70504 in effect creates a gateway to the remaining provisions in Chapter 705. And there are some pretty good examples of additional statutes within Chapter 705, not just 70592, but all sorts of other statutes in Chapter 705 that have no application whatsoever to a general plan statutory village. For example, Section 70523 is a section that creates a civil service commission and mandates that any municipality adopting a plan of government have a civil service commission. In a general plan statutory municipality, there is no such thing as a civil service employee. The fire and police officers in general statutory plan municipalities have very specific due process rights to which they are entitled that are outlined in chapters 731 and 733. And every other employee in a general statutory plan municipality is an at-will employee. There's another example off the top of my head, 70514, which calls for municipalities under an optional plan to elect a chairman and a vice chairman of council. That's totally in opposition to what happens in a general statutory plan municipality, where the mayor functions as president of council and council elects a council pro tempore. So there are myriad examples of this, but the point is that you don't get to 70592. You don't get to the other provisions in Chapter 705 unless the electors of the municipality have first chosen to do so. And that can be seen in the language of 705 itself. And it can also be seen in the way that the legislature amended 70592. I note that while they reference Article 2, Section 38, they do not accept Article 18, Section 2. And again, Article Section 18.2 kind of rules the day here. Additional laws only apply to municipalities if they've elected for them to do so. And it's clear that the laws of 705 don't apply to general statutory plan municipalities. The electorate must choose for them to apply.
Thank you, Mr. McConville. And Mr. Bay, you'll be here. We're going to start winding this up. But I'm going to ask Mr. Musson briefly to, you're our attorney with the board. You've read Mr. Bray's position, Mr. McConville's position. You've written to us as our clients, as our attorney. Where do you end up on this whole argument?
I think I agree with Mr. McConville. The amendment in 2017 created two changes. One, the petitions are only valid for 90 days, and then the timing of the election. And then this language about the notwithstanding or exempting certain sections of the Constitution, which I'm not sure the legislature could do that. Trying to understand those within the context of the actual amendment to the section itself and the obligation to avoid this constitutional question, I think the statute trying to exempt sections of the revised code from the requirement or the ability to recall an elected official, I think you have to look at it in context with the rest of Chapter 705, which requires the voters to specifically approve a recall provision, which I think exercising the powers under Article 18, Section 7, their home rule powers, get you outside of the due process protections that Mrs. Dave Chappelle was speaking about that are contained in Article 2, Section 38. Those notice and hearing requirements in Article 2, Section 38, which I don't think the revised code can exempt everyone from being subject to, apply unless the voters or the municipality exercise their authority of local self-government to condition the ability to hold office on the recall. So Section 238 governs until the voters exercise their power of local self-government under Article 18, is my opinion.
And Mr. Bray, to wind it up, sir.
Just a couple of points I think we've covered. You've probably heard more from me than you. Article 2, Section 38, I agree with the council for the board. The General Assembly has no authority to repeal or limit the application of the constitutional provision. Why then did the General Assembly refer to Article 2, Section 38? And they did so because in at least 2 cases that came up before the Ohio Supreme Court, people misunderstood Article 2, Section 38 as having anything to do with recall elections. So I think that was more a matter of clarification that they agreed with the court when it said in 1948 and agreed with the court when it said in 1976 that Article 2, Section 38 has nothing to do with recall elections and does not limit the ability of the General Assembly to provide for them by general law. Secondly, this is a case of first impression. And obviously the board can vote 4-0 either way or 3-1, or can vote 2-2, in which case obviously the Secretary of State will look into it and break the tie. And I imagine that whichever side wins, we may have further decision makers. I don't know that, but that's always a possibility. I think that this is, however, something that's pretty clear. And I respectfully disagree with the council and the board. You can't ignore the words. And all I've heard is in light of the other provisions of the statute, which this amendment states you can't consider, other statutes you can't consider. In light of the title of the chapter, which by the way is not part of the statute. It's not something that's binding upon the statute. It's as if the Constitution requires provisions in 705 to be not general provisions. And there's nothing in the Constitution that prohibits the General Assembly from doing as it done, making this statute, not the other ones, it still apply only to, we're not saying that everything in chapter 1705 applies to statutory municipalities. We are saying that 705.92 applies to statutory municipalities because that is the only statute in that chapter in which the General Assembly says you can't look at the other statutes to limit this provision. And if the board says you can, the board is saying those words don't mean anything. And you've got to give effect to the words that they use.
Thank you, Mr. Bray. I appreciate your advocacy on behalf of the petitioners. I'll note that part of our package and part of this record includes your written analysis and your communications to this board. Also, Mr. McConville's opinion is in here. And so I'm going to make this all part of the record. Despite your wonderful advocacy on behalf of petitioners, I will move not to certify the recall petitions for the mayor of Newburgh Heights. And the basis for that is, I believe, in addition to the arguments we've heard here today and the written argument we have part of the record, Newburgh Heights Village has not had a voter-approved charter providing for the recall in their charter as described under 700592. And for that reason and others set forth on the record, I am going to support that motion. There's a second.
Second.
Thank you. Any other question or comments?
It is an interesting question. Just a quick comment. I mean, it is a case of first impression. In the absence of, clear cut, I mean, I appreciate all the impari meriteria and all the Latin phrases and all the statutory interpretation, but it's really difficult for us and for me if there's no real law to guide us and there is no definitive law that would overturn Lockhart. From my perspective, that seems to me to still be good law. And I know we all may disagree about where we are. And then, maybe there's a way to avoid and harmonize the provisions. Your view is that there is not. But even if we couldn't do that in some way, it just seems a constitutional piece is just way too far to go without some definitive guidance. So I would just make those comments. Thank you for your advocacy, both of you all. But I will support the motion.
Thank you. Ms. Ficken, anything else?
Well said. It's my very concern too. So.
And I'll note too, there is a transcript of this proceeding here today if either of the parties want to avail themselves of it. There is a motion. It's been seconded. All those in favor signify by saying aye.
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 Passes unanimously. Thank you, Mr. Bray. Thank you, Mr. McConville. Thank you, Mr. Messon. Okay, on to, and I will move to acknowledge the resignations from and appointments to elected office. That's set forth in our agenda. Justin Burns, Beechwood City Council, has resigned. Joshua Mintz, Beechwood Board of Education, resignation. Tom Lahiv, Brooklyn Heights Village Council. Maureen Fallen Adler, Fairview Park City Council, Ward 3. Tina Stafford Marbury, Maple Heights Board of Education member. Marie Gallo, Parma Heights City Council member, Council at Large. Kim Thomas, Richmond Heights City Council, Ward 1. Kimberly Edwards, Warrensville Heights City Council, Ward 7. Those are the resignations. And the appointments to office are Josephine Chan, Beechwood Board of Education. Ray Burzen, Brooklyn Heights Village Council. Doreen Jackson, Fairview Park Board of Education. Robert Guff, Highland Heights City Council. Sharia Granger, Maple Heights Board of Education. Angela Arnold, Orange Board of Education. Sue Derrico, Parma Heights City Council member at large, and Thomas Clark, Strongsville City Council. If there's a second.
Again.
Thank you. Any question or comment? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. And also, as required by statute, we have to acknowledge the intent to retire from elected office. It's all judges. Richard Bell from the Court of Common Pleas, term ending 1/2/2023. Stephen Gall, Court of Common Pleas, term ending 1/1/2023. Francine Goldberg, Court of Common Pleas, Domestic Relations, the term ending 1/12/2023. Diane Palos, Court of Common Pleas, Domestic Relations, term ending 1/17/2023. And Joan Sinnenberg, Court of Common Pleas, General Division, term ending 1/11/2023. If there's a second.
Second.
Thank you. Any question or comment? Hearing none, all those in favor signify by saying aye.
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 And Mr. Lawler, is this something, acknowledgement of withdrawal of candidates and issues from the May 3rd, 2022 primary election? There's quite a, maybe you can walk me through this, so I can just incorporate what's set forth here in our agenda instead of reciting all the names.
Brent Lawler, Manager, Canada District Services. Good morning.
Good morning.
So you have in front of you, you have a withdrawal of an issue from Broadview Heights. They made a mistake on it. They removed it. They refiled it, so it should be on the ballot in May.
Thank you. Okay.
You have a number of judges on the front page there that have withdrawn.
Okay.
And then the second page and third and fourth are all precinct commitments of the Democratic Party. Really almost 99% of them have an issue with the petition, and lots of them have refiled as either refiled as a candidate to become valid, or they have refiled as a running candidate.
So the question is for me then, so for those candidates and issues that have been withdrawn but were refiled, then do they appear in our docket and as that we will in our certification portion of the docket?
Of the write-ins, because the write-in deadline is not November 22nd.
So, Mr. Lawler, thank you for summarizing it. We've got a withdrawal in Broadview Heights. We've got a number of judicial candidates set forth. And then the bulk of these other pages all relate to withdrawal of Democratic County Central Committee candidates, correct? And however, there are two individuals, Shayla Davis, Ms. Davis and Mr. Young, who have issue with their withdrawal. Is that, I haven't.
That is correct.
Okay, and we're not acting on those just yet.
We're not, no.
Right, we're going to hear them and then make a decision. Correct. Okay. So I will move, thank you, Mr. Lawler, for clearing that up for me. I will move to acknowledge the withdrawal of candidates and issues from the May 3rd, 2022 primary election ballot as set forth in our agenda. And just in summary, a withdrawal of an issue from Broadview Heights, Ordinance 01/2022. The withdrawal of candidates, Thomas J. Kelly, Grant McKay, Sanford Watson, Kira Krivosh, and Bishop Choi, all running for judge, except Mr. Choi was running for a council member in District 7, as well as all this Democratic County Central Committee candidates are set forth in the agenda. If there's a second.
Second.
Thank you. Any other question or comment? Okay, hearing none, all those in favor signify by saying aye.
Aye.
The second?
Aye.
Oh, great, okay. Do we want to hear then Ms. Davis's complaint?
Just a point of clarification. So you all have this list. And both Ms. Davis and Mr. Young are not on the challenges of, we're asking you not to certify these people to the ballot.
Okay.
They are not on this list. We have separated them out because we were aware that these two individuals would be coming to the meeting. today.
Okay.
Where's that? I don't think I have that. I'm not sure I have that. Is that in our packet? I don't see that.
Is it number, what you're holding up there, Mr. Lawler, is that under?
No, they have a separate like tab.
Oh,
Yeah, with their name, looking for their name.
I mean, I have information about Davis and Young. but
Yeah,
okay.
that makes sense.
Okay, thank you.
Where is that?
It should be in there.
It's, yeah,
Is it under a tab in particular? I didn't
it's
see.
his name, yeah, the name.
Okay. Great, so I'm looking,
I
it
think she
is,
needs the tab.
Sure, that's okay, she got it. Thank you.
Oh, okay.
okay, so let me just, so where are we at in this? Are we on, you holding up a piece of paper, so petitions for board review, is that it, Mr. Lawler?
Yes, that would be done for, we were going to hear the two individuals that are here today.
Okay,
If there's anyone else who would hear, we would hear them also. I don't know if there are. Then we would do this,
I see.
which is the people who are petitions that are in question that we do not believe are valid and their reasons are stated. And once we've completed all that, then we would certify their meeting candidate.
So we'll hear from Ms. Davis, and then the other individuals, Mr. Young,
Correct.
I believe, and then we'll look to the matter here of what the staff has recommended not to certify.
Correct.
And act on that. Once we're done with that, then we can move on to certification.
Right.
Okay, thank you very much. Ms. Davis, and do you want to, you provided us a summary of Mrs. Davis, your office has provided us a summary. You want to kind of just give us a summary, Mr. Lawler, on Ms. Davis? And Ms. Davis, are you here? Yeah, why don't you come up? Ma'am. Go ahead, Mr. Lawler.
Thank you. Ken had filed a petition with 6 signatures. 5 are required for Democratic Precinct Commitment. She's running for Garfield High School Ward 4 Precinct C. The registration department and Ms. Edwards, the registration manager, reviewed the petitions and came up with 4 valid, making the petition short by 1. We've had discussions with Ms. Davis and 2 of the people, which I believe are our children, Anthony Gamble and Shara Davis. Shara Davis printed her signature, and Anthony's signature does not match what's on file with the Board of Elections. As you're aware, we're required to match signatures as they are on file with the Board of Elections. So you have a sheet of paper that looks like this. Try to do a comparison of signatures so that you have it easier to review. Of course, the first one is the signature on file, and then you have a registration card, and then you have signature, registration signature for Anthony, and then her daughter is the second one. So our recommendation is she is short by 1 signature, and she should not be certified to the ballot.
Terrific. Thank you. I appreciate it. Ms. Davis, I'm going to put you under oath here and then hear from you, the board will. Stephen, would you put her under oath, please?
Raise your hand, please. You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. Ms. Davis,
Yes.
we're here to hear from
Good
you.
morning.
Good morning.
Thank you guys for allowing me to speak this morning. I'm here because my daughter signed my petition and she printed her first name. The print is consistent with her registration and anything that she printed. Why she did that, she has submitted a letter to me that is notarized, saying that it is in fact her.
Excuse me, so we don't have a copy of that letter, do we? Have you made copies for us?
No, I did not, I'm sorry.
Okay, why don't we, I mean, we need to see what you're submitting as evidence in support of your position, that's all. So go ahead, you have a letter from your daughter that's notarized.
You know, stating that it was her, it was an error. She was trying to ensure that her name was spelled, her first name was spelled out correctly. The last name is signed. Obviously, I didn't get more signatures because they're my children. They're registered voters. I know them to be actual registered voters in my household. They've signed all 5 of my petitions in the past, and there's never been an issue or concern. My daughter couldn't be here today because she's at work, so she decided to write the letter, have it notarized, and ask that I come and, you know, share it with you all.
If you've seen the signature cards for your children, correct?
Yes.
And would you agree? I mean, your at least your son's signature for his registration doesn't look like what he signed in a petition for.
And that's correct. He's gone back to school in Chicago. I have no clue if he's changed his signature. You know, I asked him about it. Why is it different? And he said, Mom, I just signed it. you know.
And as to your daughter's signature, so you would agree that she did print her name and that printed signature looks different from the signature that we have on record from her provisional envelope signature. Have you seen that?
Yes, Mr. Waller did provide you with that. So yes, it does look different. However, it does match her printed name, and it was just an error on her part trying to over clarify something. And as a lay citizen, she's not aware that that is not acceptable.
Any questions from Ms. Davis?
No, do we have is there any discretion here, or is the rule that the signature,
We
it's
have
like the
discretion.
signature, we do have discretion.
Yeah, so here's my thoughts. I appreciate Mr. Lawler and his shot, and I understand why they got us here to this point. I don't believe he had the copy of this letter submitted to him just yet. And even then, it comes to us, and he properly brought it to our attention. And in light of this letter now from your daughter and your presence down here under oath, Ms. Davis, I, with the utmost respect for our staff, will move to have your name certified to the Democratic County Central Committee if there's a second.
There is a second, you can see on her sworn affidavit, her printed name matches and the signature matches, so I'm comfortable with that.
I just had a question, and because it's notarized too, we can give that more weight than just, right?
It's a sworn statement. I haven't
Okay.
seen the
Oh,
jurat.
I'm just saying it is notarized, it's not
It's
just record.
She's,
Yeah,
Mr. Chair, we'll make this part of the record.
yeah, you the original.
I think she's authenticating her signature.
I would make the original part of the record.
I provided Mary with the original.
Oh, okay, perfect, all right. Yeah, so, okay, I feel comfortable then, based on our legal counsel's recommendation.
Okay, thank you. There's a motion and a second. Any other question or comment from Ms. Davis? Hearing none, all those in favor signify by saying aye.
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 Thank you. Thank you, Ms. Davis. Thank you. Thank you, Mr. Lawler. On that matter, and then we have Mr. Young, a 17-year-old candidate. And is Mr. Young here?
I'm here.
All right, terrific. Thank you for attending, Mr. Young. We're going to have Mr. Lawler kind of summarize the staff's position on your Central Committee, County Central Committee petitions, and then we'll hear from you, sir.
William Young is running for the Democratic County Central Committee for Lakewood Ward 2 Precinct G. The issue with his petition is he will not be 18 on the day of the election on May 3rd, 2022. His 18th birthday is May the 26th. County Central Committee, as with State Central Committee candidates, are elected at the May primary. They are not nominated. We have Mr. Karati and myself to talk to Assistant Prosecutor Munson. He concurs that his age disqualifies him from continuing as a qualified elector for purposes of election to the position.
Thank
We
you.
state the sections of the ORC and the controlling committee. Each member of the controlling shall be a resident and qualified elector of the district. In the election petition manual states that the candidates that are 17-year-olds could only vote on candidates seeking election nomination. They cannot vote on county central, state central, or questions and issues. So he would not be able to even vote for himself.
Gotcha. Oh, okay, thank you, Mr. Lawler. Sir, would you like to be heard, Mr. Young?
Yes, I would.
Okay, we can hear you. Go ahead.
Thank you. Good morning. My name is William Young, as stated before. I came to this meeting today to address the board about the validity of my candidacy for the Lakewood Precinct 2G Captain position. A few weeks after filing my petitions and the declaration of my candidacy with the Cuyahoga Board of Elections, I received an email telling me that my candidacy had been deemed invalid because I would not turn 18 until 23 days after the primary election. I was provided with quotes from the Ohio Revised Code and from the election officials manual, which a legal counsel had interpreted to mean that I was ineligible to run. I have come before you today to appeal to the board that they allow me to run for the primary. The portion of the Ohio Revised Code that was used in the decision of my candidacy was section 3517.02, titled Controlling Committees of Major or Intermediate Political Party. The quoted section was, each member of a controlling committee shall be a resident and qualified elector of the district, ward, or precinct that the member is elected to represent. As I have lived in the same house for 15 years, of the two state requirements, it seemed that I was not seen as a qualified elector. According to my own research of the Ohio Revised Code, I found the definition of qualified elector in section 3501.01 under subheading N, which states that an elector or qualified elector means that a person having the qualifications provided by law to be entitled to vote. I believe that I fit both of these requirements as a registered voter. The second document that was cited in the decision to invalidate my candidacy was the election officials manual, which under which was stated, voters who are 17 years old as of the primary election are not permitted to vote on any of the following: state party central committee, county party central committee questions and issues. General stuff. Looking further down in the document, you'll find section 1.05 titled Signers, which lists the requirements of the people who sign petitions to be on the ballot. Listed under must be a qualified elector of Ohio is a 17-year-old who is 18 years old by the election at which the candidate or issue will appear on the ballot and is properly registered to vote may sign a petition. Looking at the wording and searching the document shows that while I will not be eligible to vote on the position I am running for, there is no statement regarding a 17-year-old candidate in and of itself. The state law uses qualified elector as a synonym for registered voter. I am a registered voter who will be receiving an official ballot on the day of the primary election and that ballot will be counted as part of the election. This means I fit under the general definition of qualified elector under state law. As I have mentioned previously, I have lived in my precinct for the past decade and a half, meaning that I fit both of the state requirements to run. I believe that it would be in the best interests of everybody involved that I would be able to run on this ballot or issue so that I may be able to run, and so that future 18-year-old people who will be turning 18 by general elections will also be able to run for these county positions. As I probably don't need to remind you that many precinct captain positions in Ohio are left empty and others are left uncontested, as many older people do not seem to want to do this line of work. I know that the chances of me getting onto this ballot and of being certified by the board are probably half and half at best, but you miss 100% of the opportunities you don't take. Thank you for listening.
Well spoken, Mr. Young. I can see you being an attorney someday.
Yeah.
Very well spoken. And Mr. Musson, you heard from Mr. Young, and what's our attorney's position on this matter?
Yes, Chairman Hastings, he makes a good argument, but unfortunately the board is bound by the Ohio Elections Officials Manual and the directives of the Secretary of State that holds that a 17-year-old is ineligible to vote for elections at the primary. They can nominate candidates for the general election, but the actual election of individuals themselves that occurs on the primary date are not something that a 17-year-old can vote on.
So he's making a distinction between voting and running though. How are you interpreting that? That's what I'm hearing, saying, okay, I may not be eligible to vote, but the definition of qualified elector may mean that I can still run. Is that the argument?
That's the way I understand it, but to be a qualified elector for purposes of this election, to run as a committee person, you have to be a qualified elector for this race. Yes, to vote. Oh no, but no, to be qualified for that office, you have to be a qualified elector for the committee person.
You have to be 18.
Yeah.
Yes.
So it's the age.
Yeah.
Okay.
At the time of the race.
You have to be 18 at the time of the race, and I believe we heard him say he's going to be 18 23 days after that. Is that correct?
Correct, for when the primary is currently scheduled.
So it's the age
Right.
disqualified.
Since he's not a qualified elector for this particular precinct election, and for purposes of the definition.
That is my.
Okay, I understand what you're saying.
Yes.
Thank you. And just, we may have you back here because they just may move that primary. And then you can be on the ballot. So I'm reluctantly going to have to move not to certify you to the Democratic Central Committee, Lakewood Ward 2, Precinct G, Mr. Young, despite your wonderful advocacy. If there's a second. Thank you.
That was a good question though. So if that does happen though, we can revisit this, correct?
I don't know what the directives are.
Well, how, if we certify voters today, how would we be able
Last
to?
deadline was February 2nd, the writing deadline was February 22nd.
It's-
So to write in.
Oh, okay,
So the party can-
The deadline's passed. Right.
okay.
All right.
Question.
Any other
Question.
comment?
Question?
Who is speaking?
My mother's.
Hi, since he's a minor, I figured having a parent sitting next to him would be a good plan. So I've been sitting next to him this whole time and he's feeling, we don't know about, I'm
But ma'am,
a very
would you
frequent
first-
voter.
Ma'am, first identify yourself, please, and your address. Okay.
Sorry, Amelia Young, 1620 Victoria Avenue, which I really don't like reading into a live stream, but I am William Young's mother, and just I had a question about what you were all just saying about the primary possibly being moved.
So, Ms. Young, what the answer from Mr. Lawler was, there's a filing deadline that has not changed. You had to file for certain offices by February 2nd. So
Mhm.
even if they move the primary, they're not changing the filing deadline. You follow?
Yes.
Okay, so he would not be eligible to get on the ballot regardless if they move the primary.
Well, he met the filing deadline and you're rejecting him based on the date of the current date of the primary. So if the primary gets
correct.
moved to after his 18th birthday, then the reason for denying him access to being on the ballot changes.
We're required to certify today by the Secretary of State. We have to do it by 4 p.m. So we can't put this decision off. We have to decide today based on the information that we have available about the primary.
Can you make note on this line of what's being submitted to the Secretary of State, that if the primary move to June, you have an additional candidate that is qualified?
That is something the Secretary would have to direct us to, and the law would have to be changed likely too in the legislature to allow this. It's a unique situation that is problems being created because of the deadlock, with the Supreme Court and the lines being drawn. So while I brought it up just to kind of make an irony of all this, I didn't mean to open Pandora's box. It's unfortunate that your son is not going to be able to be on the ballot regardless of when the primary is held.
Okay, because I just wanted to clarify that since you brought up the primary potentially being moved to just after his 18th birthday.
If there was an opportunity for him to get on that ballot, then I think we'd all advocate for that down the road, but we're just not permitted to under the law. So we have no choice but to make this decision.
Please also,
Thank you.
I request that you clarify with the Secretary of State whether qualified elector is a general term, as it appears in the Ohio Revised Code, being synonymous with registered voter, as my son mentioned.
We have an attorney that represents us, and we're going to rely on our attorney. Okay?
I understand that. I
I
feel that I agree with my son that this is a gray area and that it's worthy of consideration. And yes, he is planning on going to law school. Thanks for noticing.
Well, he did a wonderful job advocating for himself, and thank you for speaking to us. Thank you. Any other comment or question from the board members?
Well, I would just say I'm glad that you're 17 and engaged in the process. I too voted at 17 and it was a limited ballot, so I'm excited to see you doing that as well. So, and I appreciate your arguments. You were very well spoken on this topic. So thank you.
Okay.
Thank you.
Thank you. Okay, all those in favor of the motion not to certify Mr. Young, signify by saying aye.
Aye.
Okay, now we're on to a third motion passes unanimously. What's next then, Mr. Lawler?
You have 4 pages of petitions for board review.
Well, I'm sorry, we have these 2 pages.
The director is making more copies, because he only had 2 pages, but I have 4.
Oh, okay.
I better run out.
Okay, so we're going to take a break while he brings this in, okay, just in a moment. Just Okay, so are these in on
Yeah. Issue.
all four of them?
Yeah.
There are three of them. I gave you 2 pages. You should all, I got 4 of them. It's in my- okay, I got 4.
Thank you.
We're going to take a recess. How did Joe eat it? So, took a recess.
Mr. Bird, B-R-A-Y. So B-R-E-Y, let me just see.
Because these are people that are not disputing.
Yeah, we should just ask a question if anybody's here.
Gotcha. Thank you, Brett.
Yeah. Donald Gray, B-R-E-Y.
So if Mr. Gray would he go to Supreme Court?
He could, I think, he could file a mandamus in the Supreme
Or
Court.
he could go to the 8th
He
district?
could go to the 8th too.
But the problem with the 8th is if you don't agree there, you got to still go to Supreme
Yeah,
Court.
you gotta, yeah. And this type of issue might be a good one for the Supreme Court to decide, since it's such a broad.
And I think you touched on it, and you, in your memo to us, you take, hey, 791, let's just call it 91, and 92 can be reconciled.
Yeah.
But you got to get, right,
It's a two-step.
that's proper,
It's not contrary.
right, and you said, and they never got past 91.
Right.
Because they didn't adopt this.
Right. I think that's how they would interpret, they wouldn't get into the constitutional issue.
Right.
It's just, hey, let's reconcile these, they can be read together. They added the language. I'm not sure why they added that language, but.
And the legislature puts language that makes sense a lot of times. I mean,
Yeah.
I don't know what they meant. And I think the legislative it is important to at least consider.
Well, it's such a big change. That would generate discussion.
Right.
Because that was very broad implications.
Right.
So that's a radical change for a lot of statutory municipalities.
I mean, I see his argument.
It's too big of a.
Yeah, it just, I mean, he did travel all the way up.
I mean, that language is very stupid.
Yeah,
I
notwithstanding.
mean, it's.
Well, I've been talking, they put bad language in statutes all the time.
All the time, right. I mean, for case of first impression, far be it from us, some other court.
Oh, and they, right.
Yeah, they all fit.
Mercer County Board of Elections did the same thing. There was an attempt to recall statutory.
Did the same thing that we did.
Yeah.
So
they
is
came
Lockford
to
still
say-
good law?
Yeah, I think so. But unless there's a voter approved charter amendment, the voters have the ability to adopt a recall,
Right.
but they have to adopt a recall. for it. So
And they did a nice job on
They're not
the
tenants.
on the memo.
I flubbed around at the table here.
They were.
I know.
I get all
No, I
talking
was just
about.
That was good. It was, I thought it was very clear,
But thanks.
very helpful. Your January one and
All right, thank you. We're all back here in session.
thanks for that.
Yeah, so, no, absolutely. So, and all board members are present.
Yeah.
Mr. Lawler, on to the next process of certification. What are we looking at next, sir?
Okay, so you have 4 pages, that look like this, and they're labeled as petitions for board review. Except for the first one, who's running for a county council, District 1. All the remainder are Democrats and community members. I would ask if you would ask the audience if there's anyone here to speak on any of the precinct committeemen, that would, we can separate them out. Otherwise, we can go over the list quickly, and we just ask that you do one motion, not place them on the ballot.
Sure. So let just make sure everybody's, I think these are all set forth in our
Okay,
packages.
that makes sense.
Here. In our agenda, they're all,
They're different
here.
ones,
No,
yeah.
you have all four right there.
Oh, I do, okay, good. Oh,
Yeah,
you're
so
good.
you will look, yeah, you know.
Okay, I got you.
So we have this summary set forth in our agenda of the staff is recommending individuals not to be certified for a variety of reasons. I'll summarize those reasons. One candidate did not have the minimum 50 qualifying signatures. And then the bulk of the other candidates are for Democratic precinct persons did not indicate the municipality, ward, and or precinct in the description of the office sought. Another group of candidates are listed, candidate listed a different municipality, ward, or precinct than in which they are registered. Another group of matters not to be certified are issues the circulator did, the issue is the circulator did complete the circulated clause, did not complete the circulated clause completely. Another issue, the candidates did not have the minimum 5 qualifying signatures. And another issue being that the candidate did not complete the candidacy clause on their petition. Another issue being the candidate dated the candidacy clause of the petition after obtaining the signature of voters. And so those are the categories that the staff is recommending these individuals not be certified.
There's one more.
What's
Oh,
the,
there's one more.
That's the very bottom. The current status date, was received late.
Oh,
Even
she
after
after,
the filing
okay, was
deadline.
received after the,
via U.S. Postal Service after the filing
Thank you.
To
deadline.
be clear, it was received on 2/4, not, 2/2. Okay.
Can we just clarify, if there's just the typo in the one for the group that did not complete, there's a typo in here, something that says they did complete.
Issues, it's-
Second page, second one.
Yeah,
I'll-
yeah.
I'll put not in there. We sent it
But
to
if it's part of the record, let's just make sure it does say in fact that they did not complete the circulator clause completely.
the agenda will so note that, thank you for pointing that out.
Yes.
I'll send a new copy.
Right, so I've summarized the categories. Is there anyone that is online or present that wants to be heard about their petition not being certified? Okay, not hearing any. I will move to not certify these individuals set forth on our agenda.
Second.
Second, and there any other question or comment?
I mean, these are requirements that are identified in the elections manual. I mean, there is no room for any change on these. These are strict, we have strict compliance requirements with these.
That's correct, and Mark reviewed them all.
And these individuals been contacted or?
Everyone received the letter, right?
Okay, thank you.
Or email, they all received the letter.
Did anybody respond to you directly or?
Tons of them withdrew in the past.
So many of them will be certified.
It's right there.
Yeah, right.
Okay.
Thank you.
So anyone on this is now will not be able to file this right now.
Were they advised by us that they could do that?
They were not, because we're not allowed to give legal advice to people, so. Most people knew that, so.
Okay, I'm just wondering, hey, did they know that? Or it sounds like so many of them knew it, so, okay. All right.
Thank you. I know you have a very busy time of season for your shop at doing all this. So we got a motion, seconded, and no further question or comment. All those in favor signify by saying aye.
Aye.
Motion passes unanimously. Thank you, Mr. Lawler. Now on to the certification of candidates,
I
correct?
actually have two lists, one for the main candidates, the judge and county offices, and then the second one should be precinct committee.
The committee. What tab here is the committee?
We have candidate.
They have an A tab,
Under 8.
B tab.
Yeah, I got it.
Oh, it's under the C tab. Okay, there it is. Thank you, Mr. Johnny. All right, so we have in our agenda, I will move to certify the candidates to the May primary. As set forth in our agenda, we have 3 different categories. One, certification of candidates for the May 3rd primary election. Those are countywide offices or county positions. Then we have a B tab, which deals with issues to be certified to the May primary. And then the C tab, which sets forth the certification of the Democratic Party Central Committee candidates for May 3rd. So I'll move to certify these individuals set forth in the agenda. If there's a second.
Second.
Thank you. Any other question or comment? Hearing none, all those in favor signify by saying aye.
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 Motion passed. Thank you, Mr. Wall. I know you've been very busy. Thank you for your staff.
We did include the issues as well.
Yes, I did. Thank you. So, okay, we're on to the acknowledgement of the precinct election officials' performance report.
We're going to have Assistant Manager Marlene Robinson present this. She was integral in getting this report put together, and we do this report based on the election officials manual having us do this after election review process of our poll workers.
Thank you. Good morning, Ms. Robinson.
Good morning. My name is Marlene Robinson-Stafford, and I'm the Assistant Manager in the Election Officials Department. And I'm going to present the Precinct Election Official Performance Summary. It covers 3 elections in the fall of 2021. The election day workers of Cuyahoga County gained a lot of experience in 2021. They served in 3 back-to-back elections in the fall, August, September, and November. And actually in 2021, there were a total of 7 elections in totality last year. Despite facing recruitment challenges that we had throughout and the ongoing pandemic and some of the nationwide shortages, we recruited over 6,286 people were hired to serve in those 3 elections. Many election officials were also very flexible and willing to step into roles outside of their normal placement of polling locations, outside of their usual assignments. Some of the criteria set forth in our election official manual, as well as feedback gathered from our call center and our post-election surveys from workers and voters, we notice an overall trend of performance improvement beyond the elections. Some of the worker statistics and information that we have: the number of polling locations in August, we had 157 polling locations. In September, 138, and in November, 295. Our target was to hire in August 2,110 election officials, and we actually had 1,833 that worked, and a number of 23% new election officials we were able to recruit for that election. We also had outs for no-shows and so forth of 8.9%. Then as we move forward to September, we had a target goal of recruiting 1,741 election officials, and we did actually recruit 1,464, and out of that, 3.7 were also new election officials, and a 16% average for that election. And then finally, for November, our goal was to recruit 3,793 election officials. We actually had 2,989 that worked. 6.1% were new election officials, and we had 21.2% hours for that election. With the election officials, we also record the average age of our workers. So in August, the overall average age was 64. In September was 61, and in November was 62. And if you compare that with a look back to November of 2020, the average age was age 57 for the elections. So then as we looked at doing some comment reviews and a deeper dive, as we look at future appointments for election officials, there's several categories that we look at. So one is promotion. So that would be taking a precinct election official and someone maybe recommended by another voting location manager or by our recruiters and promoting them to a management position, a voting location manager, voting location deputy. And there's 29 future appointments. This is collectively for all 3 elections. Then relocations would be someone possibly having some interpersonal relationship problems at the location. We think it's still a good worker, but maybe not a good fit for that particular polling location. And then removals would be for people that were failing to follow procedures, and we felt that we needed to remove them. And the 2 other categories are on watch and demotion. We had 68 on watch and 20 demotions. We are requiring that both on watch and demotions do attend training again. And so on watch would be a performance issue that we would have on watch for them. And the demotion could have been someone that we promoted to that on location management position as a temporary fill-in, and maybe it just wasn't the right role for them. We feel they're better suited as a precinct election official. And they also may have failed benchmarks that we set forth based on the performance summary and evaluation. So our training classes, there's several types of training classes that we offer. We offer online classes, and a total of 3,576 people completed online training last year through August, September, November. And then our guided digital learning. Our guided digital learning, for information on that, would be one-on-one personal assistance where our trainer actually goes to a library. They have locations both east and west, and actually assists that person that may have a challenge with computer usage. And they're there with them to get through the online training. We had a total of 46 people that completed that last year. And then in-person training, we had 2,314 people who did in-person training in those 3 elections, for a total of 5,936 people that we trained for an election.
Quick question, if I could. So in the categories of removal, on watch, and demotion of our co-workers for future, so the performance issues for the folks in those categories primarily related to the fact that they're new. I mean, I'm assuming that, you know, these folks are probably new to working for us or new to the training. I just don't recall seeing so many high numbers, frankly, but I just, you know, just wondering if the performance issue is related to the fact that these are new workers.
If someone that did relate to being new, there's a reason why we put them on watch, or someone that we felt we put into a managerial position, they wasn't a good suit for them, then we demoted them, because they're still a good worker, but a lot of the management role requires some other things for them to be able to do as far as monitoring of classification.
Okay.
Thank you, Ms. Robinson. It's a very thorough report. It really is. You took a deep dive, and I appreciate your overview and summary of that. Is this something that we send to the Secretary of State, this actual report gets sent to them?
No, if this report, it just stays with us.
I would, if you get the chance, send it to the Secretary of State. I think it could be a model template for other jurisdictions. I know it's, training is so important, and I really appreciate the work you and Break does and all the staff there and poll workers. And this is just a wonderful summary to see.
And we do want to encourage them. I mean, it's not, you know, it's three strikes and you're out. I mean, we are appreciative of the fact that this is a public service and they're giving of their time, and we should continue to give them all the resources and opportunities they can to serve. So thank you for all the hard work that's done by you and the folks in the department.
Excellent job. Thank you. I will move to acknowledge this PEO performance report and the excellent job done, Ms. Robinson. Thank you. So second?
Second.
Any other question or comment? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. All right. I will move, there'll be some comment after this, but I'll just tee it up. I will move to approve to renew the delivery and return of the voting equipment to the voting locations contract with Midfits, doing business as Berman Moving and Storage under subdivision B, Article 1 of the contract, not to, between us and Berman's, not to exceed $51,463.50 for the first renewal period of May 3rd, 2022 through November 2nd, 2022. If there's a second.
Second.
Ms. Susi, good morning.
Good morning. Andrew Zuby, Fiscal Manager. This is exercising our right to renew for a 6-month period to get us through the May election. It expires May 2nd, right before the May 3rd election, and it's at the same rates that we currently have.
So if we have any change, how will that affect what we're acting on today? So there's a change to a primary, second primary.
It covers the time period from May 3rd through November 2nd.
Okay.
So 6 months, so any election, if it moves, it covers it.
Okay.
Right. In the event if there were 2 elections, everyone say there occurs that there's not.
Exactly. Prayers have already been sent out.
There you go. But if they were, we don't have that funding encumbered, but what we have is the rate structure that they would bill us for based on per location delivery, which then we would have to go, well, hopefully the state would come up with funding for it, but ultimately we would go to the county and ask for that.
Okay.
All right. Any other question or comment? Hearing none, all those in favor signify by saying aye.
Aye.
Motion passes unanimously.
Mr. Chair, before we go to the next item, though, so we are not, I know we don't approve vouchers under $25,000.
We don't have to, correct.
I did want to just note the line item for one. I don't see it on here for some reason. Maybe I have it wrong. But I needed to recuse myself for approving the voucher for the Academy of CLE Ohio Law Conference section that I attended. That was for my registration. I know it's probably hyper technical, but
No, sure.
I just want to make sure for the record. When we vote on that, I will not be voting. I will recuse myself from that one item. Sorry.
Okay, no, thank you for pointing that out.
Thank you.
I will move to approve to suspend the contract with Tenet Software Solutions providing for online poll workers management solution software, election force under the authority of subdivision I3, Article 4 of that contract between tenants. I understand this is a mutual agreement between the parties. Mr. Pilati, if you can summarize the reason for that.
Sure. So what Election Force is, it's a 10X software product that we utilize for our online poll worker management. Some of the functionality that's included in Force is this is where someone goes to our website, that we collect their poll worker applications. Our staff internally use this for the administrative function of assigning the poll worker to a polling location to work on election day. And then this is also where an individual, a poll worker self-signs up, puts himself into a training class. And so we first used this product in the November 2020 presidential election. And it was at that point that the Secretary of State allowed boards of elections to engage in online poll worker training. And that is in response to the COVID pandemic. So we used this product for the first time in November 2020. It was a good product, but it definitely had some challenges, and the implementation was a quick implementation. By the time we were allowed to use it, and we had to figure out training and implement it. So in 2021, our goal was provide 10X with input on what they needed to improve upon. We entered into a contract, this board, with 10X. And at that point in time when we did that, I had said that if this doesn't work out, we'll be back here again talking about not using or suspending this product. So throughout 21, our staff in the Election Officials Department worked with 10X. We implemented an update in 2021. There was some improvements, but there's still more work to be done. 10X came out with another update for us. This was prior to the August election, but however, because of the proximity to that release being published, and we here internally at the Board of Elections have an operational policy, kind of unwritten, that we don't implement something new in the election cycle, because no matter what the product is, it fixes one thing and it unintentionally maybe breaks something else that we're not aware about. So we had to push that off till after the fall election cycle, in which we had those 4 elections. Throughout that fall, the big issue we had was speed. The system just does not work fast. When you would hit enter on a dead entry screen, it's reasonable you would expect for the screen to advance within 1 to 2 seconds. Oftentimes this was taking 30 seconds for the screen to advance. And if you multiply that by the number of transactions that we do, it's just not an efficient way for us to do business. As well as some of the structure we found that, when we put people in a polling location, we do a lot of movement. We do a lot of movement based upon call-offs and other things like that. So it's a lot of steps that were involved to do those types of transactions, and at 30 seconds of transaction, that's just not good. So we had these issues. We were making 10X aware of these issues as we went through. Staff in that department had weekly standing calls with 10X to make them aware, and 10X was working to try to resolve these things. Ultimately, another release came out. Staff looked at that in the test server in December, and through that testing, some of these key issues that I just talked about still exist. So we had a phone call with the owner of 10X and his staff, made him aware that while yes, you've done updates, these updates don't meet the needs of what we need. And so we informed 10X that at this meeting today, Tony and I would be recommending that we suspend the use of this product because it just does not serve for efficient operations at this point in time. 10X agreed with some of these issues that we provided. So we have that same understanding that we're not using this product. But part of making this decision is that Tony and I, working with staff, have to ensure that we have a way to still engage in this functionality that we have to have. And so we do. And so Robin and the IT staff, working with the election official staff, came up with ways that we can walk away or step away from Force and still do what we need to do. One of those is using a software product called NAC that we use prior to Force. That's where someone can self-sign up for a training class as well as submit their application. Staff will use DIMS, our voter registration database, to make assignments. They were doing that already with Force, so there was this mirror. So now we'll just have all this information in DIMS. And email communication was an issue that we had with the 10X product, and that we send oftentimes large emails out to all our workers, whether it's, giving them an update or telling them, hey, engage in training, whatever it might be. Those emails, what we found was that they always didn't go in a timely manner when we hit send. They would show up hours later, sometimes the next day, and we needed that instantaneously. Working with the county IT department, the county uses a program called Constant Contact. They gave us a free license for that. And so that is a third-party vendor that focuses on online marketing measures, so mass emails. And so we're able to use that. So we've accounted for the things that we need to. The one item that staff now is focusing on with their discussions with 10X is credentials for training. So you have Force, which was the online management, and then you have 10X University, which is actually the online training portal where the videos and all that exists. That program works well. We want to continue to use that, but you have to have credentials to get in there. Those were generated by Force. There is a way that you don't have to use that Force generated credential, and that's what staff will be focusing on with them.
So it's a mutual agreement to suspend.
Yes.
You have a plan going forward to replace the functionalities that Force did provide.
Yes.
Is there a plan to like regroup in 6 months with them and say, where are we at with your Force, reconfiguration, or how's it in any improvements, or is there a plan for that yet?
Yeah, so what 10X is going to do is keep their testing portal open. They have a list of modifications that we would need to be completed in Cuyahoga County to go back to Force. 10X will work on those modifications. They will make us aware of when they publish some of those modifications, and as time allows, staff will go ahead and test that in the test environment. After the May cycle, we can take a little bit deeper dive into some of that testing and see, is the functionality at a level in which we feel that we can go ahead and use the product. If so, we'll have a discussion here. If not, we'll continue on with the course that we are discussing today.
Yes.
Yeah, that's just a question. And I mean, I know they have provided some good services for us and they're a good vendor and all that. I'm just concerned that it's great we have a plan going forward, but under the contract, we have service level guarantees and warranties. And it seems to me if the product, we've given them over a year to come up with a fix for this speed issue. Are we getting something back from the 50,000, or maybe, I don't know if we paid the 50,000 for the 2021 year, and if we paid for the Force product into this year, have we paid? I mean, what are we getting back? Because it doesn't work. How are we being made whole for, the fact that this, I get it, we're trying to work it out, but this, we're on the taxpayer's dollar here. So, I mean, what are we getting back?
We did pay the 2021 bill, and I think we paid that closer at time of contract approval. The 2022 bill, we have not, and 10X has voided that bill.
Okay, so what happens to the 2021 where we didn't get $50,000 worth of? I'm just asking the question, can you figure that out? I mean, it's important for me to know. I mean, that's great, we have a plan going forward, but it seems to me, arguably we should be made whole for what we purchased but did not get in 2021. That's just my view.
So to that point, I don't think we're talking about terminating for cause, that we're not talking about a breach. And if we want to go down that path, I think we need to, we're not looking for contract damages or any kind of termination for cause is my.
I didn't mention termination. I'm just mentioning the service level guarantee that's in the contract. It just seems to me there's a service guarantee, and actually I think it ties to a percentage of performance. I didn't go through it in great detail, but it is on page 3 of the contract. And I just think that we need to give some attention to, sorry, I can't find it. I know when I reviewed my materials, it's on page 3 of the contract, 13-page contract. So it speaks to service level credit and prorations of the monthly fee or the service level agreement. Unless I'm reading that wrong, and I did just glance through it, but I'd like council to take a look at it just to advise us, and we are responsible to the taxpayers for the spending of this money. If we didn't get what we purchased, and that's great, let's work it out with them, but they've had a year to fix the speed problem. It's great to suspend the contract for use of this product, and all of that is fine. But how are we made whole, and how do they implement the service guarantee? And if there's some quantification of, they've already said we're not going to charge you 50 grand. So what happens to the 50 grand we already paid? That's the question I'm asking. You don't have to answer today, but I think that we need to have some conversation with the vendor about that. That's just my opinion. So it's important.
So I made a motion and need a second for it.
I'll second your
Thank
motion.
you. Any other question or comment?
And this is on the suspension of the,
Correct, on the suspension as set forth by Mr. Bellotti.
my comments just simply, what else happens in terms of the 2021 year and the money.
I think it's a fair question, though, because they are willing to work with us on 22, so perhaps that could be revisited too.
I'm not able to, so we'll engage in those conversations.
Great, thank you.
Any other question or comment on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Motion passes unanimously. Ms. Edwards, on to the challenge of the right to vote filed by Dolores Gray against Richard Starr. Our manager of the registration department, Ms. Betty Edwards, is here to tee this matter up for us. Good morning.
Betty Edwards, manager of registration department. I'm not sure how your tabs are set up for the challenge. However, at the bottom of each of the pages of challenge, there is a number, and I will be referring to those numbers, those page numbers as I go on.
Sure.
Okay. A challenge of the right to vote and correction of the registration list, Secretary of State Form 257, dated January 22nd, 2022, was received from elector Dolores Gray. Ms. Dolores Gray is a qualified elector in Cleveland Ward 5, and that's, you can refer to tab 2A for a copy of the challenge form. According to Ms. Gray, Richard Starr lived at 9855 Memphis Avenue, Brooklyn, Ohio, 44114, and not the address he has on file with the Board of Elections. Ms. Gray stated that Mr. Starr indicated, and I quote, incorrect address on his declaration of candidacy form, which is found at 2B, stating that he did reside in Cleveland Ward 5. She further stated that the petition filed on 6/16 of 2020 lists his address as 2178 East 70th Street. Mr. Starr did not live at this address when he filed for the council seat in Ward 5. That's a quote from Ms. Gray. The challenge before the CCBOE pertains only to the registration address of Richard Starr and does not involve his candidacy or current position as Cleveland Ward 5 council. Information submitted by the challenger. I've already made reference to the declaration of candidacy at 2B and the filing date of the petition. Also at 2C, there's a copy of a direct deposit voucher from the Boys and Girls Club of Northeast Ohio, dated April 2nd of 2021 for Mr. Richard Starr. The address on that voucher is 9855 Memphis Avenue, apartment 8, Brooklyn, Ohio, 44114. At exhibit number 2B, notice of intention to pay claims, excuse me, from the office of Chapter 11 Trustee Lauren A. Hibling, dated July 30th, 2021. The communication is addressed to Richard Starr at 9855 Memphis Avenue, Brooklyn, Ohio, 44114. Staff research. As a result of the challenge filed by Ms. Gray, an investigation was conducted by the registration department into the voter registration record of Mr. Richard Starr. The following information is provided, and that information is at tab 4. Mr. Starr originally registered to vote in Cuyahoga County on April 2nd, 2007. The address at that time was 4810 Wolford Road in Warrensville Heights, Ohio. Mr. Starr changed his voter registration addresses multiple times over the years. Mr. Starr updated his voter registration address to 2178 East 70th Street, Cleveland, Ohio, 44103 on July 17, 2017. This is his current address of record in our database. Mr. Starr is regular voting in 10 elections from this address on East 70th Street. Additional information. Mr. Starr won the Cleveland Ward 5 Council race against Dolores Gray, the challenger, and he's a current member of Cleveland City Council. According to the Cuyahoga County Property Summary Report, and that's at Exhibit 2E, an individual by the name of Andrea Hayes is the property owner at the 2178 East 70th Street address, Cleveland, Ohio, 44103. There are two individuals registered to vote from this address, Mr. Richard Starr and Ms. Andrea Sharon. The Parkview Estates apartments are located at 9855 Memphis Avenue, Brooklyn, Ohio. CCBOD. Voter registration records do not currently have anyone registered at the 9855 Memphis Avenue address.
Thank you, Ms. Edwards. And Ms. Gray, is you here? Are you here today?
Yes.
Okay, and is Mr. Starr here today?
Yes.
Okay, terrific. Why don't we hear from you, Ms. Gray? And you can come up here, we'll put you under oath, and then we'll hear from you, Mr. Starr. No, we can ask. Good morning, Ms. Gray. We're going to put you under oath.
You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you heard the summary from our manager of registration, Ms. Edwards. Ms. Gray, is there anything you want to add to your challenge?
Yeah, I do have some information I'd like to add also. Would y'all like to have it, or I just speak on it?
Well, it's your challenge, so we're not going to tell you how to do it. If you want to give us documents, you're welcome to. Do you have copies of those documents?
I do.
Okay.
You have a copy of that, so we have additional copies.
I'm sorry.
I have additional copies. I'm already have mine. Oh. I might not have them all, everybody, I know I want anybody to hear.
There's two complete copies. No, that's all on copy.
Oh, that's all I got.
That's the second one.
Third one.
This is all one set. This is all one set. Is this all one
I don't
set?
have to make a copy. That's all one set.
Yeah, could you please give a copy to Mr. Starr too?
She's wanted to make it in the zoning part. I promise to be here.
Okay, let me, Ms. Gray, just let me note that two of the documents you provided us are already in our package that we have. The third document, and you'll get a copy, Mr. Starr, is, it looks like it relates to the bankruptcy filing, some documents in that regard. So let me, okay, Ms. Gray, what would you like to add?
What I'd like to say is, I'm here today on a voluntary petition for bankruptcy on Mr. Starr, which you have already issued about the copy that that when he filed the bankruptcy, this was actually voluntary, came to my door. It was a anonymous package on my door. So I approached it, looked at it, and filed a petition on it. So it was a voluntary petition that came out, and that he filed the bankruptcy on 4/16/2021, that at the address of 9855 Memphis Avenue, Brooklyn, Ohio, which is Brooklyn, Ohio. That's where the zip code is at, not in Cleveland. I do have some additional information here. I want to give her to as well. And I'm just challenging the address, basically, nothing else.
Okay, do you have an extra copy here? I'll tell you what, give Mr. Starr this. And is that for yes? Okay, please. And you know what? Give him this also,
Yeah.
right? So he's got the whole package. Thank you. Okay, Ms. Gray, is there anything else you want to add?
That's it.
Okay,
That's it for
thank
now.
you. And
Okay, ladies and gentlemen, I'm here today to show you a voluntary petition for bankruptcy for Mr. Starr. On this form, there's a section that says, where I live. On this section, Mr. Starr wrote 9855 Memphis Avenue, Apartment 8. You see, Mr. Starr executed this form April 16, 2021, under penalty of perjury in the facts and state. I have examined this petition and I declare under penalty of perjury that information is true and correct. That's on the bankruptcy form here. And further states, I understand that a false statement can result in fines of up to $250,000 or imprisonment for up to 20 years or more. Now, I can't imagine that Mr. Starr would make false statement where he lives at under the penalty of law perjury, a penalty of perjury accepted his fine and these years in prison. So we must believe that Mr. Starr swore on the oath that he is a resident of 9855 Memphis Avenue. Now here's some printout. I'm giving you at the Board of Election that shows 9855 Memphis Avenue is located in the city of Brooklyn in precinct 00-D and both at Brooklyn High School. So now we look at the Cleveland Ordinance, the Cleveland Ordinance Chapter 3, Section 5, which required a candidate for council to be in the resident of Cleveland for 12 months prior to the election. So since Mr. Starr swore on the oath on 4/16 that he was a resident of an apartment in Brooklyn, Ohio, that is also the address you will see here on his page. Also, he has on his paycheck stub, out from the document I provide you, he could not have also been a resident of Cleveland for the 12 months period. Therefore, Brooklyn, Ohio residents, Mr. Starr cannot serve as Cleveland Council President. So that's basically.
that's your challenge.
That's my challenge.
Thank you, Ms. Gray. So you understand that we're only dealing with the challenge
Yes.
where he's registered,
The resident,
not whether he can sit on council.
Right.
That time has passed.
Yeah, that
Okay?
time has passed. It's just the address.
That's right. And you just, let's set this up a little bit. The burden of proof is clear and convincing evidence. It's a little beyond preponderance, but not as high as reasonable doubt. It's kind of in between there. And the evidence you're providing us is the petition of bankruptcy that sets forth an address different from what his registration is, as well as a paycheck voucher that sets forth an address,
Right.
correct? Okay.
Right.
And understood. And is there any questions for Ms. Gray just at this time before we hear from Mr. Starr or his attorney?
I have a couple. So you indicated that this bankruptcy information was just left on your doorstep. Do you have any other evidence around, because you live on East 28th Street, did I see that correctly?
What do you mean?
Your address is East 28th Street?
My address is 2373 East 28th.
East 28th Street, yeah. I'm just wondering, have you observed that Mr. Starr does not live on East 70th Street? What evidence do you have? Because your challenge says that he does not live at the address. Do you have any other?
The challenge I have is the bankruptcy that offsets what he filed on his petition that he lives here, because the bankruptcy was filed April 16th. This petition was filed May 8th, was for May 8th and filed June 16th. And then he had a hearing July 31st with the 9855 sworn oath that he only lived at 2178 East 70th from 2018 to 2020. That's what the devil said on that, where you lived in the last 3 years. This is the only evidence I had.
Yeah, let me just tell you, the reason I'm asking is because we have had a lot of these residency cases come before us, where some people live, people can have more than one place where they live. So my question is around some of the indicia of permanent residence that we look to when we look at these cases. So they include things like you identified, but they also include, where a person sleeps at night, where they have furniture, do you have, and my question really was, since you live on East 28th Street, have you observed whether or not he resides at East Effingham Street? Do you have any evidence to really show beyond what you have that he doesn't intend to live at East Effingham? He's voted from there for multiple times. With any other evidence to show he doesn't live at East Effingham Street, or
No.
that is his intention to,
No.
for that to be his permanent residence?
No, I don't. I just have, which the resident didn't do any affidavit or any letter to me that they haven't seen him in the community since he been council person. So they know me as council person for 8 months. So they just called me and relate to me. So no, I don't have any more evidence per se in hand to state that.
To know whether or not he actually lives in East
Right.
Effingham Street? Okay,
Right.
thank you. I appreciate it.
Thank you, Ms. Gray. Mr. Starr and or his attorney. Sir, why don't you introduce yourself as the attorney?
Mr. Chairman, members of the board, my name is Zach West, and I represent Richard Starr in this matter.
Okay, do you intend to have him talk to this board?
Yeah.
Okay, let's put him under oath then, please, Stephen.
You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yeah.
Thank you.
Okay, thank you, Mr. West. Go ahead.
Thank you, sir. As you have indicated, this is a fairly straightforward case involving where Mr. Starr lives now. This is not about the candidacy or the election results from last year. Ohio defines a person's voting residence as the fixed place of habitation, and summarizing from whenever the person is absent, the person has the intention of returning to that location. Mr. Starr did temporarily reside in Brooklyn for a period of about 6 months while he was helping his brother, whose apartment he was living in, through a very nasty breakup. During that time, he continued to receive mail, and we have examples of bills from June, December, and July of last year showing that he continued to receive mail at the East 70th address. But more relevant to the board's inquiry is the fact that he recently executed a lease. He decided he needed more space than the East 70th address had for 2341 Carnegie, Cleveland, Ohio 44115. He executed that on February 7th. We have a copy of that lease, as well as a cashier's check dated February 4th for the security deposit.
Do you have copies for us?
Unfortunately, I do not. I can have. Thank you.
And Ms. Gray needs a copy too, so.
Yep. And here are the copies of the cell phone.
Is there any other records that you intend to introduce?
No, those are all of them. So again, if you look at the residency requirements, it's whenever the person is absent, the person has the intention of returning. Mr. Starr continued to receive mail at his East 70th address. He continued to stay there occasionally when his brother did not, when he was able to. And he, again, decided he needed more space when his lease was up, so he signed this new lease. He never intended Brooklyn to be a permanent address. As we said, that is his brother's apartment. He was simply helping him through a family issue. With regard to the bankruptcy, because he was living at the Memphis address when he filed, his attorney advised him to use that address. But bankruptcy, residency, and voting residency are not necessarily the same thing, so it should not be as positive that he used a different address based on where he was living the day the petition was filed. And with that, I welcome any questions, or if you would like to hear from us.
Yeah, because it says on this item too, do not list where you live now. I understand your argument is he was living elsewhere, but it does say he lived at the East 70th address until 2020. And I believe the bankruptcy was filed in 21, if I'm looking at these documents correctly. So that's, I guess, question one. How do you explain that timeline?
Excuse me, thank you, Ms. Steve. Do you have a copy of it? I see you looking. Do you have a copy of what she's referring to?
This was handed to them.
Yeah.
I mean, it's pretty, I guess it's pretty clear to say live there, like you no longer have a relationship with the residents. It says do not include where you live now.
Right, and that was filled out under advice of his bankruptcy counsel.
Okay, so, all right. And I guess my other question is, who's Andrea Sharon?
How you doing? That was my landlord, my godmother.
Okay, she live there now?
Yes.
Okay.
So do you live with her?
Yes, I did live with her, but I currently just moved on February 6th to 2341 Carnegie Avenue. 4415.
So Mr. Starr, why is on the paycheck stub too, we have his part, you've seen that of the agenda. Why is that address in Brooklyn set forth, not the one in,
Because when I was staying with my brother throughout the week, 2 or 3 times a week, I wanted to make sure my mail was secure mail and everything came back and I could make sure I did it without having to just go to storage or back and forth. So I knew I had to key to the mailbox, obviously. And I just used that as a way to make sure I had secure mail without it.
have you changed your voting address now that you've secured a new lease?
That's my goal today.
You're gonna do that today, you haven't done it yet.
He just signed a lease last week, so he intends to do it as soon as this meeting is over.
So for purposes, I mean, you gave a lot of the statements that I would like to hear from your representing your client, but for him to be sworn under oath to speak to what his intent, could you put the questions to him that would help us understand what his testimony really is around his intent to reside permanently or until February 6th at the East 70th Street address, that whether he lives there or not, whether, all of those, the indicia that you identified, be nice to have him testify to that under oath for our record, because we've already gotten direct testimony from the challenger on those issues.
Would you rather I ask questions or he testify?
However you would want to do it, you can certainly pose the questions to him and he can answer, or however you choose to do it.
All right. Can you state when you moved to the East 70th address?
That was around June of 2017.
And when did you move to the Memphis address?
I got that around shortly afterwards in 2018.
And when did you actually move there?
When I actually moved there, that was probably around 2018 right after my brother got a breakup, so I got the apartment for him.
Okay. And how long were you staying at 20th? I'm sorry, Memphis?
2 or 3 times a week.
Okay. And where did you receive most of your mail during that time period?
2178 East 70th Street, 44103, Cleveland, Ohio.
And where did you consider your permanent address during that time?
2178 East 70th Street, Cleveland, Ohio, 44103 was my permanent address.
And did you stay there during that time period?
Yes.
At the East 70th?
Correct, that's correct, East 70th Street.
And why did you put Memphis on your bankruptcy counsel? On your bankruptcy petition?
Under my lawyer, he borders when I was filing for my bankruptcy, he wanted it to match. But as you can see, when I did my bankruptcy, my ID on there was also my 2178 East 70th address, which is still on my address, on my license.
All right. And where do you reside today?
On 2341 Carnegie Ave, Cleveland, Ohio, 44115.
And when did you sign that lease, if you recall?
On February 7th of 2022.
Thank you.
Did I understand the testimony to be that was a driver's license with the East 70th Street address?
Yes.
Do we have a copy of that? You said it was attached to something. I don't see that. Maybe we can make a copy of that for the record as well.
I have that one as well. That's my old one that expired.
Well, just the current address. Well, the old one have the East 70th Street. Well, why don't we make a copy of both of them? That would be helpful because we're covering a time period.
So, are you still looking for your license? Is that?
No, we're getting copies of that.
So you gave us a picture, Mr. Wesser. It's a piece of paper that says Richard Starr, but it has a Nelson Avenue address on it.
So that's one of my former addresses that I've had.
Before East 70th?
So that's when I first opened up the credit union account. That was the address that I had.
So this doesn't do anything to support your.
No, this is, I'm sorry, we're submitting that to show the security deposit was paid to Walker Weeks for the apartment where he resides in Carnegie Avenue now.
I see that he's got this lease.
Yeah, he's got this lease and has made payment.
So this lease just demonstrates the fact that he intends to move from where? Where do you intend to move from and to?
I just came from 2178 East 70th Street, Cleveland, Ohio, 44103, to move to 2341 Carnegie Ave, Cleveland, Ohio, 44115.
I see. And you intend, is it your testimony, you intend to update your registration to date after this hearing?
Today, I plan to
That's a question. Is Andrea Sharon here today?
Well, she is not.
All right, did anyone in our departments contact her? I guess it's a question for our staff.
She looks to be the property
Right.
owner and looks to have been the property owner. I just happened to look online. She looks to have
Yes.
owned that property since May of '03.
That's what I see too. And,
She's registered at that address.
right, no, I know, I'm just saying, because she could verify that, what he's saying. All right, so, but your testimony, or under oath, I should say, is that she's a relative of yours?
Yes,
Okay,
As your godmother.
yes, correct.
all right, so she's your aunt and godmother?
She's my godmother.
Oh, just, okay, all right. So she's not a relative of yours? She's not your aunt? I might have misheard that.
Godmother.
Godmother, okay, just to be clear, sorry.
Any other questions for Mr. Starr? So, it's somewhat unique, your situation, because what you're represented to us is you're moving from an existing location. So where will you put your head down to sleep tonight, Mr. Starr?
234 Warren Carnegie Ave.
So you're effectively saying that 2178 East 70th is no longer your residence, correct?
2178 East 7th Street is no longer my residency. I have already moved to 2341 Carnegie Ave.
Okay. And you intend to change your registration?
Today I intend to change my registration.
And it's your testimony that the reason, Ms. Gray showed us, your bankruptcy petitions, that it was advice of counsel to put down the Brooklyn address.
Correct, because of my pay stub.
Okay.
I'm happy, I'm happy to make a motion to reject the challenge based on the testimony. I think that the challenger did present evidence around the bankruptcy filing, and that has been explained, but the more significant evidence to me in rebuttal of the challenge is the testimony that Mr. Starr has given today, that the Brooklyn address was a temporary address for the reason that he stated, and that his permanent residence was the East 70th Street address, and that was his intent for that to be until his recent move, his permanent address. And for those reasons, I would move to deny the challenge.
Thank you. I'll second that motion. Any other questions or comments?
I would just say for the record, what is compelling to me is the license, because I know there's some case law, but this is a factor we can consider. Obviously, the paycheck stubs being different is another factor to weigh it against, but given your testimony or explanation and the license, I would support your motion.
Thank you. Any other question or comment? And for all the reasons set forth by Ms. Chappelle and Ms. Stick, and I will support the motion too. All those in favor signify by saying aye.
Aye.
Motion passes unanimously. Thank you, Ms. Gray, Mr. Starr, for coming down. And having this matter heard.
Thank you.
Thank you.
Okay. Do we have some new business? I guess we'll go into executive session of the personnel agenda, but let's go. Any new business on election officials department?
Yes, I have just 3 items I wanted to hit on, new business. Just wanted to give just a general update on the election officials department. Tony and I have been working, or spending a lot of time with that department, as they are one of the departments that is up first kind of in the election cycle, with training starting on March 4th. We already heard today that we're making operational changes as far as the software that we use there. But there's also some other things that we are working on in the department. One of them is that we are reformatting the training manual that we provide to the precinct or to poll workers. So we've been doing focus groups with poll workers, as well as we have been surveying them, and we've been doing these surveys for several election cycles. And what we have learned is that our current poll worker manual is too bulky for poll workers to bring with them from home to the polls on election day, and it's just not all that easy for them to use anymore. And our current format actually is 11 by 17 flip chart, so it was too big for them to manage. And so we learned this through the input that we get from them. So what we are doing for this upcoming May cycle is we've converted the manual into 8.5 by 11 book format. We worked with the county print shop to figure out how we can lay it out and how we can bind it and have that ready in time for this upcoming May election, and we will have that. So this now 8.5 by 11 version of it,
will be more user-friendly. So someone, when they get it in training, they make their little notes. It's easier for them to bring to the polls with them on election day, as well as it'll be easier for us to lay it out in an electronic format online, where we can tab it and have links from the table of content to the pages. So that was what we wanted to make sure we accomplished for this May primary, which we've done that. For November, then what we can do is, now that we have all the formatting and layout done, we can even make changes to the content of it and focus on that part. Another thing that going on in that department is we mailed out, and should have hit mailboxes last week, letters to all the returning poll workers that we want to come, letting them know it's about time for them to be paying attention, that's to work, and just ask them to, if they change addresses or contact information, go ahead and reach out to us and provide that to us. So this way, when we communicate with them electronically, we have the most up-to-date emails for them, as well as if they plan to move, they give us that address information. Also, we worked on ways to try to incentivize poll workers to train earlier in the training cycle. So as we know, through the budget process, we asked for and were approved by County Council for an increase in the poll worker stipend. Previously, we paid $172, and through our budget process, we were approved to pay them $250 to be a poll worker. So what we're doing is we're increasing the base pay from 172 to 220. And then what we want to do is, if an individual trains within the first 2 weeks that we offer training, that would give them a $30 training bonus. So that would get them to the 250. If they train in weeks 3 and 4, they would get a $15 training bonus, and that would get them up to 235. And if they waited and trained at the end, they would get the 220. Reason we're doing this and trying to incentivize them to train early on in the cycle is, the sooner we know what our successes and deficiencies are, we can then change our recruitment efforts to whether geographically we're having a low response, we can reach out in that area, or if we're down one political party in our training, we can focus on that. So by taking this approach, everyone gets at least a $50 bump up in pay, but doing these training bonuses, there's an internal benefit for us to be able to do that. And we will have sufficient training, so if everybody wanted to do within the first 2 weeks, especially because a lot of it is online, we're able to handle that. Another item that we've done is we've recently submitted our application to the Ohio Supreme Court for CLE credits. We haven't heard anything from the Secretary of State that they're going to have that across the board CLE credit program. Hopefully they do come out with that. If not, though, we have put things in place in order to be able to offer that again for the May cycle. We've also reached out to our contacts and have gotten an extension to provide continuing education credits for social workers that they sign up for our training. And then Tony has already started communications with the Republican board members on some things that we could try to do to increase and get good participation from Republican poll workers. So those are just some things I wanted to kind of highlight that we're doing in that department. Again, of course, Brent was very busy getting ready for today, but also the poll worker department kind of is real busy now getting ready for that training cycle. If there's any questions, I'll take those. Otherwise, I'll move on to the next. Okay. Berman's contract extension. So we had contract extension today, and that extension extended that contract out 6 months. That 6 months is allowed per the contract at the board's request. That 6-month extension takes us right up in front of the November election. And so there's also language in the contract that by mutual agreement between us and the vendors, we can extend that further. We'd like to engage in that conversation with the vendor. And the reason we want to do that is next year in 2023, this will be bid out because we're going to have different bid specifications we have to put in based on whatever equipment we pick this year and implement next year. So a lot of this moving contract of equipment from the mover's warehouse to the polling locations is based on square footage. So how much square footage does
that equipment take for them to store in their warehouse, why they prepare to put it on trucks, how much space does it take in a truck, which then determines how many trucks, how many delivers, which then all impacts the cost. And so what we'd like to do is just finish out the year with this contract, knowing that we're not going to have different size equipment to deliver in 2022, and that we will be redoing, revamping this bid for next year in anticipation of the new equipment. We feel that, well, Berman's has really been the one entity that has been on it, and we've had a good relationship with them, and feel that that we could engage in a fair extension with them, that we're actually would probably lock in the pricing that we currently have just to finish out the year.
So let me just, we're allowed to do this under the contracting statutes in Ohio?
Yes, this was built into the original bid, so it was competitively priced at the time of the bid. So we're basing it, piggybacking on prior offering.
So you, if you do enter into these negotiations and come to an agreement that you believe is fair and reasonable, you'll have to come back to the board and have us approve it. That's correct.
Yes.
And your hope is that they'll continue the pricing consistent with what they have bid?
Yes.
Yeah,
So the contract doesn't speak to a requirement that any extension be at the same price.
In my opinion, it would have to be at the same price. They would have to mutually agree to honor that pricing. We couldn't force them.
Yeah, because to me, it would give competitive advantage to them if they were allowed, perhaps, if it didn't cover it already in the bid, if they're now able to charge us at an additional price the original bidders didn't have a chance to bid on.
Exactly.
So it would seem to me it would have to be at the same price.
Right.
Thank you for that clarification. All right, thank you, Mr. Plotty. Any other questions concerning Berman's? Thank you.
And so hopefully then we will actually be able to come back, hopefully at the next meeting with that. And then we can just be done with that for the rest of the year. And then the last item I wanted to hit on was just a quick update on some job postings here at the board. We are going to, this week and next week, either be posting new or reposting some positions here at the board. One of them, and this is in no particular order, this week we will repost our campaign finance auditor position. We previously posted it and only received 5 applications from the posting. So we need to get that back out there and drive up some interest in it. We will, unfortunately, we received notice from Mary Hannah Boyer in our IT department that she will be relocating to Pennsylvania in the coming months. And Mary Hannah is the employee who was the lead worker in updating our current website. Great employee, great person. And so we want to get she made us aware of her intent, did provide something to human resources. We don't have an end date, but we want to get going on this posting. The IT positions are sometimes the most challenging ones for us to fill. So we would like to get that up this week. We still have an open posting up for election officials in the ballot department. That's open till filled. So hopefully we'll get some more interest in that. And then by the end of next week, we want to repost our fiscal officer position and get that up. And we went through an interview process, did not identify anyone, so we want to get some applications for that. Last week, we had an election official posting in our poll worker department come down. We did get a good response to that. I think about 25 applications. So the department will work with HR to identify those applicants to take through an interview or an assessment process for that. Hopefully we can get through that process in enough time for our March 7th board meeting. That's our goal. So we have some new things that'll be going up and one that's down that we currently will be working to come forward with the next meeting.
Any questions for Mr. Plotty? Is that audit position being posted externally?
Yes, externally. And also, I forgot, I wanted to add, what the HR department is doing is kind of relaying out our applications instead of it just being a big block of text and trying to make it a little more user-friendly. So maybe it'll catch some people's eye. Utilizing Indeed, it's a job search engine, getting them up on there, as well as trying to see where else we can push it out through social media. They provide it to the political parties to email out.
and see where we go from there. Thank you. Any questions for Mr. Fly? Hearing on any public comment, Mr. Bajali?
No, Chairman.
Thank you. Okay, we have Ms. Davis, but yes.
I had originally thought I would want to move to go into executive session to get an update on a personal, but I have to be somewhere, so I'm gonna, if it's only me requesting it, then I would.
I'm just kind of doing it on your behalf.
Yeah,
So-
so I wanted to say, I'm sorry, I would like to get that update, but I won't have time to get that today.
Okay, we'll
apologize for
revisit
that.
it. We'll revisit.
Okay, great.
So we do have then one personnel item here. Your staff is recommending Matthew Flattiani?
Yes.
Right, for the position of program coordinator in the ballot department. It's a lateral movement, correct?
Lateral transfer from program coordinator to supervisor in the ballot department.
So you'll have to find a program coordinator in that department.
Right, so if this then were to be approved, that list of jobs that I just talked about, it would add then another job posting.
Well, just a quick question. It's a lateral move because the salary is the same, but the job duties are the same, coordinator and supervisor, or no?
No,
Not exactly lateral. The job duties are expanding.
it's the.
Just need clarification.
Sure, no, it's, so within the Archer report, it groups jobs by pay range. And so program coordinator and supervisor fall within that same range. So lateral in that you're going from, say, for example, one range 5 position to another range 5 position. So that's lateral versus being promotional.
But the scope of responsibility, I guess that was basically the same duties, additional. I mean, was the program coordinator supervising anyone?
They were the backup supervisor when the supervisor wasn't.
Well,
So-
basically lateral for both purposes of compensation and banding and scope of responsibility. Am I understanding that correctly?
Yeah, I mean, he will have more supervisory responsibility in this position, definitely.
Okay, any other questions? I will move to adopt the recommendation of staff for Mr. Franiani in that transfer to supervisor of ballot department. There's a second.
Second.
Thank you. Any other question or comment? Hearing none, all those in favor signify by saying aye.
Aye.
Okay. Motion passes unanimously. Is there any other business to be brought forth to the board? All right. Thank you all. Happy Valentine's Day. Have a wonderful week.
Thank you.